In this particular case, this is another case, and this is with Smoking Everywhere Incorporated and the FDA. And there's only 2 pages that I want to speak to, but I'm going to read the both pages, the whole section. There are sections, so there are multiple pages, but not too long. But I'm not going to talk really about the case itself. I want to just explain. I was explaining it on the live show last night, but I want to delve into it a little bit as to how the process works when it comes to an import ban. Comes to an import ban. So if you go to page here. So let's go through this here. Very interesting. They spell it out very clear in this particular case. So it says the FDA's import program, and this comes off of the U.S. Supreme Court website, by the way. Several federal agencies have overlapping and concurrent jurisdiction over imported products. Under the FDCA, that's Food, Drug, Cosmetic Act, FDA may request samples of food, drugs, devices, and cosmetics which are being imported or offered for import into the United States. The FDCA further provides if it appears from the examination of such samples or otherwise that such article is adulterated, misbranded, or in violation, then such article shall be refused admission. So even if it appears like it's misbranded or adulterated, it can be refused admission. Thus, the FDCA thus does not require FDA to find that an article offered for importation actually is adulterated, misbranded. Rather, the agency has a broad authority to prohibit import of any article that appears to violate FDCA. In addition, because the appearance of a violation may be based on the examination of such samples or otherwise, FDA can refuse admission to an article based upon its own examination of the product on evidence other than sampling and analytical results. So it just has to appear. When they scan every single solitary article. So on a vapor product that has a manufacturer finished product date after August 8th, 2016, comes from China somewhere, pick on Vandy Vape. You know, it could be Joytech, any of them, okay? When it goes through, we'll pick on the Icon RDA. What the heck? When the Icon RDA comes through, if they want to, I'm sure the FDA is mainly waiting for the Nickel Pure Labs Right to Be Smoke-Free Coalition's opinion of the court to know where they stand with the law before they actually enforce things. But I'm sure they know it's going through that conveyor belt, through being scanned with the Customs Border Protection Services. And if it appears that for whatever reason, for any reason for that matter, like it says, any article that appears, they can take it off, examine it, or, you know, put a stop to it and put an import ban on it. FDA coordinates with the U.S. Customs Border and Protection to ensure that FDA is notified of FDA-regulated products imported or offered for import into the United States. And I've spoken about this, but I'm going to go into it because it's an actual court case in the U.S. Supreme Court. As a first step, the importer or her representative files an entry notice and an entry bond with CBP. After CBP notifies FDA of the entry, FDA determines initially whether to admit the product into United States commerce, detain the product based on information it already has, conduct a physical examination, or obtain additional information. When FDA believes that it appears an article may be subject to refusal of admission, FDA may detain the product by issuing a notice of detention to notify the owner or consignee of the opportunity for a hearing. In some instances, FDA may detain a product as soon as it is offered for entry into the United States without first examining it or taking a sample. So they don't even have to examine the product. They could just decide to put an import ban on it like that for whatever reason. Doesn't matter. Now, they do afford a hearing, like in this particular case I'm picking on, Vandy Vape. They will give a hearing to the Vandy Vape and then shut them down as far as import ban into the United States. Now, into other countries, a whole different ball game. That can go on according to whatever country's laws are. But as far as the USA, they will put an import ban on all the Vandy Vape products because every single product they have has a manufacturer finished product date of 2017, which is well past the manufacturer finished product date of August 8, 2016. When FDA believes that it appears, I just read that. I read that too. Okay. A detention without physical examination may be based on past history of a particular company, product, or geographic region, or other information indicating that the product appears to be volatile. So it could be because they know China is importing all this crap into USA. Well, not crap literally, but all these products are flooding the US markets. Based on that past history, that'll give them enough reason to detain whatever product they want to without physical examination. They don't even have to take the product out of the box. They could just put the block right there, the import ban right in place. A hearing on a detention can take many forms, including telephone conversations and letters. The owner or consignee may introduce testimony either orally or in writing in an effort to demonstrate the admissibility of this article. A decision as to the admissibility of detained goods is made only after the importer has had an opportunity to present testimony and that testimony has been considered. If FDA concludes that the product is in compliance, the shipment may be released into United States commerce. If FDA concludes that a violation appears to exist, the product will be refused admission. Vandy Vape's products are all 2017 products. They won't even show up for the hearing. In fact, they probably won't even answer the phone. Because they're probably saying to themselves, what's the point? Just let's no longer put our Vandy Vape products in the USA. Because if they do, and they ignore the FDA, then the FDA will just simply put an import ban on their products. An owner or consignee may seek reconsideration of the decision of an FDA field office to refuse admission of a particular shipment. If the product is ultimately refused, however, the importer is required to either re-export or destroy the article under CBP or other approved supervision. So CBP will be there when they destroy whatever products it may be, or they just take it back and leave it in China. Then just this one little section here. FDA's Division of Import Operations and Policy may issue import alerts to the FDA employees located in FDA district offices who review import entries. This process allows to disseminate information efficiently and effectively throughout the field and to coordinate FDA screening efforts. The purpose of import alerts is to identify and disseminate import information, problems, relative trends, etc. A relative trend is a very good one because this goes on all the time from China. To help ensure an effective import coverage program, an import alert advises FDA field offices of ongoing problems with a specific product offered for import and suggests appropriate action such as detention for inspection and sampling. This mechanism is particularly important given the large disparity between the volume of imported products within FDA's jurisdiction and FDA's limited resources. Usually, import alerts inform FDA field personnel that FDA has sufficient evidence or other information to consider refusing admission of future shipments of an imported article. FDA field staff use the information contained in import alerts along with other information to help determine whether they will detain articles, which is what initiates the process for determining whether articles are ultimately refused entry. So they definitely have the jurisdiction, but they also have limited resources. And that's why they work hand in hand with the U.S. Customs and Border and Protection. Like it says, FDA coordinates with the U.S. Customs and Border Protection. So if the FDA doesn't have those resources, they certainly will go, and use the CBP's resources as well. And so that's pretty much it, I think, of this here. Yeah, it's pretty, and then it goes into other stuff, which I don't need the factual background of e-cigarettes. I understand all that, but the point is this import program that they have. They do have it in place. It's been in place for drugs, food, cosmetics, and now tobacco products, of course. That's how they do all this contraband, combusted cigarettes, trafficking, and all this. And then eventually they will. It's in its infancy. You have to understand, it's only been since August 8th of 2016. Eventually, they will wind up putting several import bans on several companies, if not all the companies, from China and elsewhere. And possibly even export bans, not even possibly, they will put export bans on products that are coming out of the USA into other countries that have a manufactured finished product date after August 8, 2016, plus many other things. If they find things that are misbranded or adulterated, they will put import bans on those things. Adulterated e-liquid is just as bad as spoiled food that comes from China. There was, many years ago, there was a huge ban on this Chinese food. I can't remember what it was. That this food contained, I think, mercury or something, and they put a ban on that entire import that was coming into the USA because it was making Americans sick. So a simple thing like that. And so if you have an adulterated e-liquid that's coming from China or wherever else into the USA, they'll put an import ban just on that alone. Though mainly what's coming out of the China manufacturers are hardware and software, mainly hardware. It's mainly hardware. But like it says, they don't really even have to have a reason. In fact, they don't even have to open up the box to stop it in its prints, to stop it from being imported into America. And like a situation like Fda Vape, they're not going to answer the phone call. I could guarantee that. They know they're going to lose with the FDA. Why even waste their time and money to appear in a court of law, it won't really be a court of law, it'll be an administrative hearing, to appear in an administrative hearing to say to the FDA, by the way, we know we're wrong, we're going to stop our imports into America. They figure, look, let the USA put an import ban on our products and leave it at that. So I just wanted to share that with you. And this actually comes out of the U.S. Supreme Court case. This is on the United States Supreme Court website. So this is how it's done, guys. Just want to share that with you guys. And on that point, you guys have a good one. Bye.